Hello, YouTube. I'm Vince White. I'm an employment attorney, and I'm answering publicly posted questions from YouTube users, getting the folks the answers they need from an employment attorney. And I got a question here from YouTube user Anthony Patterson. He posted this question on our video entitled "My Employer Lied, but now they're trying to change their position statement. What do I do?" And Anthony Patterson asked us, if you are awarded lawyer fees due to a state law, can those lawyer fees be calculated if you get punitive damages awarded as well? Now, to be frank, I didn't fully understand the question, so I typed a little comment response there asking for some clarification, but I haven't received that clarification, so I'm going to give a general primer on attorney's fees, lawyer fees, as you say, which I think will probably answer the bulk of questions on this topic. What are attorney's fees? In the realm of employment law, attorney's fees are generally going to be fees that are awarded if you're victorious in trial. So there's a bit of an incentive given to defendants, right, to not go to trial, to settle. And often, in many jurisdictions, and caveat here, I'm presenting everything in the context of federal court in New York State, right? Now, there are going to be state laws that are different from state to state. There's going to be procedures and potential case law. It's different in federal courts from state to state. The federal statutes are the same in all 50 states, but there can be differences as per the case law and procedure. So wherever you are, you need to check with local counsel to make sure that this is correct where you are. But general primer, let's say you go to trial, federal court in New York State. You win. Victory. For ease of math, we're going to say you win $100,000. Just for ease of math, just to keep it super simple, okay? Now, you're going to have 3 statutes, likely. It could be more, but probably about 3 statutes that you can win attorney's fees under. We'll assume this is a sexual harassment case. We're talking Title VII, the federal statute, the New York State Human Rights Law, New York City Human Rights Law. 3 really good statutes. There could be others, but let's keep it simple. Now, you might have a slightly easier time obtaining an attorney's fees award under the state laws in New York. Not to say the federal provisions aren't amazing. They are. But things can be a little bit easier with the state law in general. Okay. So you win a trial. You win that $100,000 that we said. And you go and you make your attorney's fees application. There's a lot of paperwork that goes into that. You're going to have to collect affidavits. You're going to have from other attorneys, defense counsel, plaintiff's counsel. It is a very complex and involved endeavor. But, of course, you do it because you want money from the defendants. You want to rip more money out of the bad guys, right? So that's what attorney's fees are. Now, the first thing you need to pay attention to, if you're a plaintiff, and I think most of my viewers are, a plaintiff, a potential plaintiff, or an equality enthusiast, right? That's generally what my viewers are. So if you're on your way into a litigation, if you're hiring an attorney, you need to look in your retainer agreement to see how attorney's fees awards are handled. I can tell you how we handle them, right? In that hypothetical where we won $100,000, say, we're working on a percentage. We have our percentage, which we would take of the $100,000. But let's say we had an attorney's fees award of $30,000. That's a really meager attorney's fees award, but let's just say it's $30,000. We come to our client and say, hey, the judge awarded us $30,000 attorney's fees as paid for by the defendants. So we're going to reduce the percentage you owe us by that $30,000. This makes sense, right? You don't want to exceed your percentage. That would be kind of a little piggy, a little greedy, in my opinion, right? This is not standard, though. Not everyone does that. So look at your retainer agreement on the way in and see how attorney's fees awards are handled in the retainer agreement with whatever firm you're working with, okay? The next thing I'll say about attorney's fees, and this is always kind of annoying to me, people come and say, hey, as part of my settlement award, I want you to demand attorney's fees. And I'll say, well, you can't. Attorney's fees are if you win at trial. You can't get attorney's fees in settlement. And the client will say, yeah, but I want to characterize it as attorney's fees so I don't have to pay you. I applaud you for creativity, but that is a common, like this conversation is like 20 times a year. No, right? If you're settling your case and you hired an attorney based on a percentage, if you settle your case for 50 grand or 100 grand, you're paying a percentage on whatever that settlement amount is, right? 50 grand, 100 grand, a million, whatever it is, you're paying a percentage. You can call those dollar bills whatever you like. They're attorney's fees, they're punitives, they're emotional damages, they're economic damages. And that could have tax consequences. But I've never seen a retainer agreement in which any of those things would change the fact that the attorney gets their percentage. Such a retainer agreement could exist, but it wouldn't make a lot of sense, frankly. So that's generally attorney's fees and characterizing things as attorney's fees in settlement is like a non-starter. Both sets of attorneys, your attorneys and the defense attorneys are gonna be like, no, not interested, not a thing. And even if it was a thing, it wouldn't matter. It wouldn't actually change anything. Okay. So here, you seem to be asking, in a hypothetical where you go to trial and you win punitives under a state law, and punitive damages are a class of damages that flow from retaliation claims, generally, in this field. Now, that could be, certainly that's always true under the federal laws. Certain states could have different laws, so that is a generalization, and you need to check with local counsel. Again, right? I need to keep saying that. So, in this hypothetical, you've got a state law claim. That statute affords for punitive damages, presumably for retaliation claim, and you won punitive damages. Yay for punies. Punitive damages are amazing. They can be really, really something special. Now, your question is, can you also, I think your question is at least, can you also obtain an attorney fee award after you receive punitive damages? The answer is generally, and in New York State and under the federal laws, yes. It's that simple. There's nothing about winning economic damages, emotional damages, or punitive damages that can then bar you from receiving attorney's fees, an attorney's fees award if you go to trial. But that's generally speaking, you need to check, again, with local counsel. There might be somewhere where that's not true, and you need to know, because these are some pretty major decisions you're making about your life, your trial strategy, and significant sums of money, right? So, Anthony Patterson, I hope this is helpful. Generally, attorney's fees are a very confusing and unclear topic to clients in this field. So, I hope this did a fair job at kind of getting the word out, explaining what's going on with all of this. Last thing I'll note, when you see your plaintiff's attorney who's working on a percentage tracking their hours, that freaks a lot of clients out. I mean, check your retainer agreement, but generally speaking, if we're tracking our hours, we're not doing it so we can charge our clients an hourly rate. We're doing it specifically to have those hours tracked very carefully for the attorney's fee application that can come later, so that our clients can win a larger attorney's fees award and then pay us less money in terms of our percentage, right? So it's the last thing I'll note, and I wanted to note that because I've heard, oh God, maybe 400 or 500 people be like, why is there an hourly provision in my retainer agreement? Well, it says that it's not what you're choosing. Very carefully, it lays that out. You're not choosing that. And 2, we need to establish some hourly rates for the purposes of attorney fee provisions when we're litigating that attorney's fees award later in the game, if we win at trial, right? Anyways, back to closing this out. This is like a quick primer on attorney's fees in the field of employment law. Really, more specifically, workplace discrimination, workplace sexual harassment, right? There's going to be other areas of litigation, even within employment law, that are going to have slightly different rules. So this is a loose, quick primer on the topic to give you the basics. Wherever you are, check with local counsel. And if I left some shadow here, if I left some things unexplained, ask away. Down below, tap at the keyboard. Let me know what you need to know. I'll make a video because I think people need to know these things. Because this is valuable information that can change your thinking on an issue of tactical or strategic importance. It's that simple, right? These are things you need to know because you, as the client, are the shot caller. You're making the decision, and it's kind of wild that you're making the decision without all the information. So let's get you a little bit more of that information, right? Like and subscribe if this was helpful. Helps me to help more people just like you.